We're ready to move on, sir.
Thank you, Your Honor. May it please the court. My name is Brian Lee. I represent Mr. Matthews in this appeal. I'd like to reserve 3 minutes of my time for rebuttal, please. Thank you. Case comes to the court from a summary judgment that was entered on behalf or for the defense, and the trial court found in that summary judgment that there was insufficient, well, a couple things, insufficient record evidence of either the existence of a dangerous condition or the defendant's actual or constructive notice or knowledge of any condition on the premise that caused or contributed to plaintiff's injuries. We believe that there was more than sufficient evidence presented to the trial court, and one of two things happened, and we've addressed both in the brief. Either the trial court saw the record evidence and waited, and that's why the court is using the word insufficient, meaning we're talking about the sufficiency of evidence, which trial courts cannot do, or the trial court didn't see that evidence or didn't link, do the causal link together for that, and that's why it was granted. There's a couple, those two reasons I think are bear out from the order itself, but we know from the evidence that all the evidence was there for the elements of plaintiff's claim. We know that the evidence was that, and it's from Mr. Matthews himself, that as he's walking down the stairs, there's 12 floors. As he's walking down, more and more debris is showing up in the stairwell that he's at. He's already said prior that there's debris in that stairway all the time. Not only drywall and the residue from drywall, there was work being done apparently, but also gravel, sand, stones, things of that sort from the beach. This is a beachfront condominium facility. And so all those things are there. We know that the defense knows that they're there because both of the witnesses that we've put evidence in, maintenance employees of the defendant, say that they knew that. It was always there. They even talked about high winds sort of blowing all that debris, sand, stones, gravel, whatever you want to call it, up the stairways that people are using. So much so that they have to clean it. Although we've presented evidence that it was more reactionary cleaning, at least some of the evidence that's there. And so then we know
they cleaned it regularly, because I understand the record.
The record says that they had regular intervals that they were supposed to clean it. But then there's also evidence from those same maintenance employees that we've cited in our brief that says, well, it was really more reactionary. Like when we saw it there, we cleaned it. There wasn't any kind of, evidence presented to, here's our, inspection reports of what we did. And this is when we cleaned it and it's signed off by, employee, whoever. It was basically, yeah, we knew it was there. We knew it was a problem. We have these policies and procedures to do it, but then also at the same time saying that we're reactionary as well.
So this is like the summary judgment, right?
That's correct.
No transcript of the hearing.
There was no transcript of the hearing. And I know that it's listed in there, but I think the defense talks about it, but then says that from the face of the order, we see why the trial court did it. That no transcript does become a problem when the trial court doesn't say specifically why it's granting. Maybe the trial court just says they're granting it without any explanation. But we know from and I'm looking even at their brief, which is page 26, the trial court provided the finding. The trial court told us why the court was granting it. And so we know we don't need to have the hearing to know what the trial court's supposed to be rulings were because they're part of the order. I would then go on to say that there's an argument, I think, made in the brief, unless I'm mistaking it, that there is no evidence that Mr. Matthews slipped on sand, debris, whatever you want to call it. If that's the argument that's being made, that's clearly incorrect. And I'm looking at the record 425, which is Mr. Matthews' deposition. This is defense counsel asking him. And the question is, so you slipped on this debris at the bottom of the stairwell? He says, yes. So it is very clear that he said, earlier in the deposition, he talks about kind of coming around, slipping. He falls, he sees all the debris on the floor, you know.
There also testimony from him that he wasn't sure and that the stairs didn't have anti-slip tread or whatever.
True. There is that because he does talk about there's no anti-slip treads, and that's why he tries to be careful when he's coming down because there are metal stairs and there's concrete landings. It's that kind of stairway. But when asked specifically, did you slip because of the slip treads or did you slip because of the debris? He says he slipped because of the debris. And so we have that evidence in the record here at multiple times. Debris is sort of used throughout the deposition and kind of really throughout this case as a lot of different things. It could be sand, it could be gravel, it could be drywall. To that end, the part of the answer brief says, well, he didn't know exactly what it was. I mean, he didn't know the composition of what this, quote, powdery white substance or debris was. That is not necessary. It's not something, and he has to know that. This court said that in Kinney, in a shockingly similar case where there was actual drywall. And there was these, I think this court, the opinion talks about these little seed-like things that were part of that. So it was a couple of different materials that were in there. And the plaintiff in that case said that, I think it was a he, fell on the material. And on appeal, the appellee said, well, you don't know whether it was the drywall or whether it was the seed or something else. And therefore, you can't survive summary judgment. This court said that is not the case, that a plaintiff does not have to specifically talk about the composition of what it is they fell on. All they have to have is evidence that they fell on something, and we have that in this case. And so we have, at the end of the day, we have what?
So his claim is he
Yes, Your Honor.
slipped and fell, tripped and fell on sand, stones, and stuff.
Right. And later on,
The whole case, right?
later on, he's talking about debris. That's correct. Yeah. And later on, it's, again, it's sort of the terms are sort of used interchangeably. Later on, it's debris, right? They kind of lump everything together. And that's what we have to prove. We got to prove that he slipped on something. We prove that. We have to prove actual or constructive knowledge. We prove that through constructive knowledge. Frankly, I think that might even be actual to the extent that they knew it was on that staircase, at least at some times. But even if you go to the constructive knowledge or standpoint, we're also looking at regularity, right? And this is another part of the argument that, well, it has to be that regularity in the sense of, well, there wasn't anybody else that they know of that slipped. It's not what regularity is under the statute. It's whether the condition is there's regularity, not whether the defendant knows that a bunch of other people have slipped and fell. And that's not part of any case in front of this court or any court in Florida for good reason. That you.
Well, I mean, if somebody has slipped, then it would go to whether or not they knew about a dangerous condition. And the fact, I assume the argument they were trying to make, there were no other falls, it wasn't a dangerous condition.
Sure, but I could see that. I don't think they were making that particular argument. I think they were making the argument that because there were no prior incidents, that means that there's no constructive knowledge, right? So that it's almost a disconnect from the condition to say, well, because we don't, and I see these arguments sometimes in stores where maybe there's a condition that is one type of condition, right? But then the plaintiff slips on something else. And, the plaintiff was then talking about, okay, well, this is the condition. And the defense comes in and says, well, maybe that's not really what you slipped on. There was and there were prior incidents about this thing, which might have been a grape, but not this thing, which was drops from a ceiling. Right. So there is an argument, I think, that you could do with that. That just wasn't this case. It was clear that the debris that we were talking about was what everyone saw and what the defendant knew about. That's what caused it. Unless the court has any questions for me, I would rely on our briefs, and I would reserve the rest of my time for rebuttal.
You'll have your 3 minutes.
Thank you, Your Honor.
Thank you.
Morning, Your Honors, and may it please the court. My name is Paul Milberg, and I represent the Appellee Landmark Tower in this case. And just for reference for prior comments, this is my first and apparently my last time arguing in this courtroom. So
You're welcome to come to St. Petersburg, sir.
I hope to do that at some time, and I hope that the court will indulge me in doing so. Let me jump in a little bit with both feet here and talk about where we kind of ended. I think it is important to note that there needs to be notice of a dangerous condition, and I think the court noticed there was no proof of a dangerous condition. I'll go through my argument in detail, but I wanted to address because it was implied that that wasn't what was being argued. That is what's being argued. The plaintiff himself is the only witness to this case. And he didn't report it after the fact. And his testimony is very clear that he is unclear as to what occurred and what he slipped on. He said he saw a white substance after he hit the ground. He did talk about debris. But again, to get to a dangerous condition, you have to have some sort of knowledge of what the condition might be. So I want to make it clear we are discussing the lack of a dangerous condition here. Again, the appellate presents, the appeal presents, I should say, a single dispositive question: whether the trial court properly recognized the boundary between permissible inference and impermissible speculation. Again, we have no other witnesses here. Mr. Matthews was very unclear in his testimony. We can go through that as to what caused his fall. So therefore, it's speculation here, pure speculation as to what he slipped in.
There's
Stuff.
So you need him to say, I slipped on sand.
I need him to say he slipped.
I slipped on, the board. I slipped on the stair. When he's surrounded by stuff.
The appellant himself, in the record 422 line 13, offers up the fact that he could have slipped on anything. That's pretty clearly unclear. And again, to have a dangerous condition, have notice of that dangerous condition, we can't have this repetitive stacking of inferences, one upon another. I slipped, and I saw debris, thus I slipped on debris. The court noticed that he did offer up himself alternative conditions that may have caused his fall.
I am correct that he's rushing down the stairs to catch a flight.
The testimony is that he and his wife were leaving the building to catch a flight. He did testify he was jittery. That's in the record. Again, I have that testimony talking about the cause of the fall. He said he was jittery. I apologize. I can find that reference in a minute. But he said that he was worried about the treads. The court noted that he thought there was non-slip treads there. That could have caused a fall. We don't know. It's pure speculation. So this notice issue, we had no prior falls. The maintenance people that we talk about testifying are 24 years of history here. They're, again, that foundational speculation of what dangerous condition might have caused his fall starts the chain of continued speculation and those stacking of inferences. So in this case, again, it's a transient substance case. So we do know that first, he has to establish that it was a dangerous condition. We've talked about that, and I've kind of jumped into that out of order. But again, if you're going to have a transient substance case establishing dangerous condition, the composition of that, whether it was gravel, whether it was sand at the beach, whether it was a combination of that, while you don't have to necessarily know that, you have to know what you slipped in. You have to be able to identify. He said it was a white substance. He didn't know what that substance was. Clearly, he said when he was asked, so sand, he said, okay, I'll go with that. Again, there's no clear dangerous condition that we can rely on. Second landlord tower have to have constructive notice of the dangerous condition. Again, I've touched upon that. To have constructive notice, no prior incidents in years. We are aware of sand. We're aware of debris blowing in. We take measures to address that. To imply that regular maintenance that has apparently been effective is somehow notice of a dangerous condition supposes that there was ever a dangerous condition in and of itself.
We have a beachfront condo and they check it 3 times a week.
I think the appellant pointed out, you could call it reactionary, but I think the testimony is fairly clear that there was a regular maintenance schedule 3 times a week. There was a regular schedule by the maintenance supervisor once a week. And if there were issues, they were addressed.
Well, common sense tells us when people are schlepping back and forth from the beach at a condo, the sand is going to accumulate. Isn't that fair?
I don't think it's fair because that's not the facts here. Again, it is a beachfront condo. Sand may accumulate. I can agree with that, but there's no testimony of a dangerous accumulation, a dangerous condition that we have notice of, Your Honor. I mean, the fact that we're asking that question is supposition. Could that occur? It could. Did it with any degree of regularity that created a dangerous condition? It occurred with regularity, but never a dangerous condition under the law that was established by any facts in this case. Other than that, maintenance was done, maintenance was effective, there had never been any falls, and there had never been any notice. And again, there's all this talk about construction debris, gravel, white substance. If we don't know what it is, and nobody was given the opportunity, no photos, no notice, how can we assume under the law, make an assumption or a presumption that it was a accumulation of sand that was somehow dangerous and caused his fall when he doesn't know what caused his fall? We look at the cases, water on the floor at Publix, water at the floor in Winn-Dixie's, a great crush. This isn't that case. Those cases were after the fact, almost every one of them after the fact was determined it was water. Did you get it wrong? It was water, it was oil. Did you get it wrong? It was water, it was a crushed grape. That's different than, I just don't know. I slipped, I fell, I'm essentially presuming because there's been sand and debris that that's what it was. Again, in this case, even if it was sand, even if it was debris that was there, if you don't know what you slipped on, how am I supposed to defend against that? How am I supposed to defend against a case where the dangerous condition itself is not identifiable? It's different than not identified or it's not identifiable. So, and again, you have to presume. Again, he mentioned he was jittery. We went through all that. He mentioned that he was in a hurry. He did mention that again, I don't want to harp on it too much, but he said it could be anything, not Michael. When Matthew's undisputed testimony is viewed in the most favorable light, again, it leaves us with that first speculation, that first level of speculation. What did he fall in? He offers no evidence whatsoever. We've talked about it again. Maintenance. He offers no evidence that my client knew about any sand on the stairs before his fall. We know sand can blow in. We know it accumulated. All the cases that talk about this sort of reasonable presumption that there was sand or debris or anything that piled up, there's evidence of prior accumulations. We've got cases where there's sand and water on the boardwalk, and people have seen it days before and they slipped and fell on it. We have cases where there's presumptions that water was on the floor because the plaintiff was standing before the aisle for 15, 20 minutes, and cases cited by both parties. 15, 20 minutes standing for the aisle. Nobody walked through the aisle. Nobody heard anything, any spill. She walked down the aisle. She slips and falls. The little case, by the way. And so it was a reasonable presumption that what she slipped in, water there, was there for a sufficient length of time, and nobody had to address it because for 15, 20 minutes, the plaintiff stood there and did not see anything occur. And so for 15, 20 minutes, that must have sat on the floor or longer. In this case, the plaintiff wrongly assumes that sand was there for any length of time because we conduct regular maintenance. The fact that we conduct regular maintenance doesn't punish us and create some presumption that there must have been sand there the day he fell that was there for any sufficient length of time, or debris, or whatever we want to call it. It could have been there for 2 minutes, whatever caused him to fall, or it could have been there for a year. Well, let's not say a year, 3 days. The court's pointed out 3-day maintenance schedule. Was it there for 3 days? Was it there for a minute? There's no way. There's no way that there can be competent evidence put forward that it was there for any particular length of time. The plaintiff didn't know. He can't testify to it. It wasn't reported. It wasn't known to us for weeks afterwards. So we are left with just this presumption that cannot be overcome by that it was there. A favorable presumption for the plaintiff assumes that it was there at the time he fell. That's all we can assume. That's all we can assume. His wife preceded him down the stairs minutes before. I don't know how they get past that, or how they say, because we clean every 3 days and we have a regular maintenance schedule, then somehow, which again, accepting what the appellant brings in the most favorable light. How does he determine how long? He does not know. Just that we have a regular maintenance schedule and no prior falls. So again, when the court found that there was no dangerous condition, I don't believe that they can find, the court could have found it, reasonably found a dangerous condition under any facts that may have been presented, the facts that were before the court. Again, the law is clear when you have these presumptions that are required to move on to the next layer. You have to presume that the condition was there before you get on to presume it there for a sufficient length of time. He can't tell us, to the exclusion of any other reasonable conclusion, what the substance was that caused him to fall, or what caused him to fall. Again, treads, jittery, white substance, rocks, sand. There's all kinds of potential, but he's saying it's sand or this white substance. The next level we get to is, how did we have a notice of that? Well, how do you get to that notice if you don't have the first level of what the dangerous condition was? When you get to the second level, did we have notice? How do I disprove or prove notice? In this case, you have to prove that the dangerous condition existed. Reasonable. Again, not whether it was water or whatever it was. What was it? Could we have had notice of it? We don't know, because again, we don't know what he slipped in. Cases cited by the plaintiff for the ability to somewhat speculate. You got cases like Reggie, which deal with store employees testifying about garbage in an area that was regularly garbage cans overflowing, that they had 30 to 90 minute intervals to clean that up. Again, we can understand that. That's sort of a reasonable speculation when the plaintiff slips in garbage or some substance on the floor in an area that's been identified. Finance case, this plaintiff's interviewed fact, or prevented from introducing fact evidence regarding receipts that were regularly on the floor. Court said that was maybe not necessarily, but maybe dispositive evidence that would have allowed a presumption. We don't have that here, other than the plaintiff saying, on that day I was coming down and I saw accumulations of debris. The appellant then assumes that Landmark Towers failed to take reasonable action to prevent this sort of dangerous condition. Again, they want to rely upon the fact that we did maintenance. That's it, that we did maintenance. There's no other testimony here to say that what we did was unreasonable, that we had notice for any reason, because of the dangerous condition because we did maintenance and cleaned. Because the plaintiff, the appellant can't bridge the gap from the presence to causation in this case. We've got this chain that we have to look to. What was the dangerous condition? Uncertain, and we can't exclude multiple causes. Or recognize that. What they have an established dangerous condition. Then we must move on to the fact that that caused his fall. He says, we don't have to go further than him saying, could have been anything. It could have been anything. Again, Your Honor, this is a case where there's no evidence that sand was present other than the plaintiff's claim, plaintiff's testimony. There's no evidence of what exactly he slipped in. Even the plaintiff doesn't know he slipped in. The appellant doesn't know he slipped in. We don't know that it caused his fall, but he said it could have been anything. There were other factors. And if you can't eliminate those other factors, reasonably eliminate them, which there's no evidence you can here, he himself brought them up, then you don't get to move on to the next factor, which is that it existed for long enough. If we don't know what it is, how do we presume it existed long enough? If you want to present circumstantial evidence to say that we cleaned 3 times a week, the court can, it's a beachside condo. Perhaps that's not enough. Perhaps. But it's another supposition based upon 2 prior suppositions. So to get there, I think that fails as well. And then again, did Landmark Towers fail to act? You have to have proof that we had notice if we were failed to act. The plaintiff and the appellant in this case have not proved any sort of lack of notice on our part. A jury can only make reasonable inferences based on actual circumstances. In this case, again, the court's noted we don't have a transcript of what the judge said, but I think I agree. I think that the foundation that the judge put in her order, there was no dangerous condition, is a clear understanding of the case as a whole, because a dangerous condition can't just be sand on the steps, water on the floor. In looking at this case, you have to look at it as a progression. The plaintiff has to establish that he had something that he could identify as causing his fall. When you say it could have been anything, and you don't rule out the non-slip treads, his own unsteadiness, and you don't rule that out, and then you move on to the next supposition is that there was notice and a duty. Each stacking of those inferences creates a situation where going back, there's, with everything that was available to the court, there's no way to determine that all the steps were met, or that a jury could reasonably find for the plaintiff or the appellant in this case. And for all those reasons stated in our brief, unless we have, Your Honors, unless we have further questions, we would rely on the authority that we've cited in our briefs and arguing this matter. And thank you very much for your time.
Thank you, Mr. Miller. You leave 3 minutes.
Thank you, Your Honor. So yes, the plaintiff does have that testimony. The plaintiff talks about what he slept on. The plaintiff talked about seeing it there before, that it's been there many times before. It's always there. And the appellee wants you to disregard that, to say, well, it's just the plaintiff saying that. No one else is saying that. And so therefore, the trial court was right. And disregarding that, that is not the summary judgment standard. Judge Black, right at the beginning of argument, asked me, we are from a summary judgment. That's what we are from. We are not from a jury. The jury didn't hear the evidence that set forth and found themselves that we don't think this is a dangerous condition, or we don't think they had constructive notice, or we think that their guidelines and the policies and procedures were adequate. And so therefore we believe that there was no negligence on behalf of the defendant. None of that happened in this case. And every single one of those things is what the trial court took away from the jury, because the trial court would have had to find each of those things to find out that there was no record evidence to do that. And that is not the case in here. As far as the transitory foreign substance, there was a lot of objects talking about that. The case law is very clear throughout all of the circuits, district courts of appeal, that a transitory foreign substance or object is defined as liquid object that is located where it does not belong. This was sand, debris, whatever it was, drywall, on a concrete stairway, 2 floors up. That is not on the beach. And so that is by definition where it belongs. And it's not just substances that we see.
What was the evidence that the sand had been there or the, whatever that debris was, had been there, for longer than a day or anything? Like how long it had been there?
The condition itself, which is debris, sand, those things, there's testimony from the plaintiff that she had seen that before there.
Okay, but that debris.
And that debris,
Because
sure.
if
Well,
we don't know if
Yeah.
it's obviously not the same debris. But
Sure.
that debris, how long it had been there? Was there any evidence on that?
As far as that particular sand, no, I don't believe there was.
Because you would agree that the sand the day before that it swept up, I mean,
If it was,
if it was swept up. and
Sure.
There's no evidence how long that debris had been on that stuff.
that particular debris, I don't think that there was someone that said, yeah, I saw that sand there an hour before, 2 hours before. There was no one that said that. But there was also testimony from the maintenance employees that they saw sand, debris, stuff on those steps all the time.
And that they also said that when they did see it,
Mhm.
the one manager said that when he
Sure.
did see it, he brushed it off.
Correct. And I think, Your Honor, Judge Smith, that lends itself to a jury because the emphasis of that. So what the appellee wants to say is that, well, when we saw stuff there, we swept it up. We got it off the stairs. Well, we know it was on the stairs. And so we're not talking about something that is a drop,
Then you get to, is it a dangerous condition? The fact
Sure.
that it's there,
right?
is it dangerous?
Yes, and we have cases that talk about that, specifically with sand being a dangerous condition. Number one, it's a dangerous condition if it's somewhere where it's not supposed to
And
be.
in cases,
Taylor versus Tolbert, which
were they under the same summary judgment standard?
they were not, but the summary judgment standard did not change what is a dangerous condition or what's not. The summary judgment standard obviously changed that we now have to put forth evidence to prove the case, whereas we could have sort of stepped back and waited to see if the defense did. But the summary judgment standard did not change whether something's a dangerous condition or not. And
You don't have to wrap it up.
yes, Your Honor, thank you. For all those reasons, Judge, for everything in the briefs, we would ask that the court reverse the decision. Thanks so much.
Thank you both.
Thank you, Your Honor.
Our next case is green space in Platinum versus I hope I pronounced that correctly.
Didn't say UBK Santoshi.
Yes, sir.
Yeah.